when you have Tanu Bedi, an advocate from Punjab and Haryana High Court, from our place, you are quite sure that since I have seen her evolving as a lawyer as such, that she would be fully prepared to make you understand not only the aspects of ground of arrest, the march of law, but also she will be marching ahead with the events as they unfold in her usual style. And the previous session in respect of the bails was well appreciated. And therefore, we had been receiving requests that in respect of grounds of arrest, if she could also elucidate in the same fashion. But I know that whenever she comes, she has a different trick in her sleeves of making the things understand. So I will not take much time, and I will request Tanu to share her knowledge. And just a caveat, because some people always feel that we will be doing sessions purely on English, but it will be a mix, just like as we say on a lot of news channels, it will be a combo of Hindi English. So over to you, Tanu, and thank you for accepting our invite.
Thank you so much, Vikas, once again for organizing these sessions for last so many years so well. And this time the caption of all these sessions and webinar has been 75 years of Constitution. So it gives me some extra pleasure, extra happiness to be part of this exercise undertaken by you and your team. Heartiest congratulations to you, as well as everybody else who is responsible behind the success of CLS, beyond CLS. And thank you to all the people who have joined here in the Zoom session, whose names I can read, and also for those who have joined on YouTube channel, whom I'm not able to see so far. Thank you so much for taking your time out for being a part of this journey, which I believe is important not only for a lawyer, but for every citizen to know that what are their rights when the law knocks at their door and they are arrested by the law enforcement authorities. जैसे कि हमने पहले ही कहा कि हमारा ये सेशन इंग्लिश और हिंदी दोनों में ही होगा, because I personally believe that when we are talking in this session, it should not become a classroom lecture which is very boring, and though it has to be as per the idea of monologue, we will not be interacting much, but I would like that I should get a feel that I'm talking to somebody, even if I'm not getting any response on your windows. But I would appreciate if, like last time, all of you remain active on your chat, and whatever I say, then you start writing about it. I'll see if I can save some time for the end. I can read the messages, get back to you, and also acknowledge all of you who participated and answered rightly whatever I was asking and discussing. चलिए start करते हैं आज की जर्नी इन सब बातों से हटके. 75 years of Indian Constitution, which tells us कि हमें 75 साल हो गए हैं जब हमें हमारे फंडामेंटल राइट्स मिले, लेकिन आज भी हमें ये सोचना पड़ता है, ये डिस्कस करना पड़ता है, व्हाट आर दोज राइट्स, व्हाट हैपेंस इफ दे आर वायलेटेड, एंड व्हाट कैन वी डू टू एनफोर्स देम. आज का जो हमारा टॉपिक है बेसिकली इट्स ग्राउंड ऑफ अरेस्ट, मार्च ऑफ लॉ. But I cannot say it will be only about criminal justice or fundamental rights. But as I will be sharing with you what journey has been on this topic of ground of arrest so far in our courts, it will give all the lawyers, especially the young lawyers, a message that we always have to keep our ears, mind, eyes, everything open so that we can be very innovative with our arguments. As you will see that something which was right in front of us in our constitution, in our statute books for almost 73 years did not materialize into something very special which could result in the restoration of liberty which has been deprived. So that all of us, especially the lawyers, after being innovative, we can bring the real justice to the litigants because of whom the system exists, though we lawyers get a chance to earn our livelihood as well. आज का मेरा टॉपिक, I will be taking you chronologically. एक कहानी की तरह, हिस्ट्री की तरह हम जाएंगे. शुरू में क्या था, बीच में क्या हुआ, और एंड में हम कहाँ तक पहुंचे. बट ये सारी की सारी जर्नी would be covering the 5 major headings that why these ground of arrest matters. What are the constitutional provisions, statutory provision under general law as well as specific law? Judgments कौन सी है, and what is the road ahead for us to take away from this session so that we can do something different in our practice when we fight for the rights of our clients before the courts. सबसे पहले why it matters. सबको पता है सर्विस मैटर्स में जो लोग करते हैं उनको तो ये बहुत इंपॉर्टेंट फ्रेज है. I'm sure if somebody is active and hearing and type it on the chart, आपको बिना सुने कुछ नहीं किया जाएगा. You will not be condemned unheard. There is a very important phrase which is very important in service law, but somehow, as far as criminal law is concerned and the power of arrest of the law enforcement agency is concerned, this phrase is absolutely non-existent. The phrase is, nobody typed, Audi alterum partem. बिना सुने, बिना समझे, बिना आपकी बात, आपकी साइड की कहानी सुने आपको कंडेम नहीं किया जाएगा. But what happens when a criminal case is registered? You are immediately arrested. Yes, one answer I got is absolutely right. So in criminal law, you are not heard before you are arrested. But what if you are not being told for what you are arrested? Then it will be double jeopardy. You are not being heard, you're not being even told. So the provision of law says that even if we are not hearing you for why you should not be arrested, we will tell you and we will make you hear our side of story that why are you being arrested. So that is the foundation, that is the reason why there is provision of information of ground of arrest at the time of the arrest. Next step. Was it always like this? How the march started? What was the first step? I did my research only for this session, not before arguing in the courts, that whether we had this provision before the Constitution came into picture in 1950. We had an enactment called Code of Criminal Procedure Code, which was enacted in 1898. I could not find any provision like 50 CRPC, which came in 1973. There were provision like other section 57, which was 6061, that anybody who's arrested has to be taken before the magistrate within 24 hours. But there was no provision that ground of arrest has to be communicated, has to be informed, has to be told to the person who's arrested in the earlier code. So the very first time the Indian courts, judiciary, got the provision to interpret and apply to the persons who were arrested was in Constitution, Article 22. But before that, there was a judgment of House of Lords, which is now mentioned in the judgments when this ground of arrest is gaining the momentum and people are getting their liberty back when the provision is not complied with. The judgment of House of Lords in 1947, Christie versus Lichinski. I'll be sharing the citation of all these judgments by way of a screenshot in the end, where for the first time the court said, if the person is arrested without being informed why the person has been arrested, it will amount to false imprisonment and damages have to be given. We will see when I'll be discussing with you the judgment passed by the Indian courts, though the arrest has been termed as illegal, has been quashed and liberty has been restored. But so far, I have not been able to find any judgment where damages have been given on account of that the ground of arrest were not properly intimated to the arrestee. The Constitution came for the first time on 26th January 1950. We got two articles, Article 21 and Article 22. To understand the importance of furnishing grounds of arrest to the arrested person, both the articles are important. Article 21, everybody knows. Everyone who's a part of this session, is a lawyer, knows that Article 21 says no person shall be deprived of his life or personal liberty except according to procedure established by law. इसका मतलब अगर लॉ है तभी आपकी लिबर्टी को आपसे लिया जा सकता है. इफ देयर इज नो लॉ, देयर इज नो प्रोसीजर, द लिबर्टी कैन नॉट बी टेकन अवे. वी ऑल्सो नो दैट दैट प्रोसीजर, even though initially has to be but technical procedure, but after 1976 of Menaka Gandhi's judgment, you will be getting citation in the end. The law is very clear that the procedure which is prescribed for deprivation of liberty has to be just, fair, and reasonable. Now, Article 22 of the Constitution of India comes after Article 21. Article 21 22 clause 1 very clearly says no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest. So in 1950, this becomes the law of the land. The Constitution says nobody can be arrested until and unless they have been intimated, informed about their grounds for arrest. There was a similar provision in clause 5 of that article about the detention laws, because there was a caveat, there was a proviso in this provision that this provision, this section, this article 22, first and second about arrestee person will not be applicable to the person who are detained under detention laws. But there also Constitution specifically provided that if a person is arrested under any law providing for preventive detention, that person also has to be communicated about the grounds as soon as possible, and also he shall be afforded the earlier opportunity for making a representation against the order. If anybody later on compares Article 22 clause 1 and Article 22 clause 5, they will find two major differences, and that will be very, very important for us when we argue about the person, about the liberty of a person who is arrested, not detained under preventive detention, because clause 5 only says a person has to be communicated. It does not say cannot be detained. Whereas Article 22 clause 1 specifically says no person arrested shall be detained. So the onus of providing the ground of arrest information is much more when it is not under preventive detention laws. And other changes in the change of the language, Article 22 clause 1 says information, informed, whereas Article 22 clause 5 says communication. So as I understand is that Article 22 starts where the Article 21 ends. Article 21 ensures that nobody's liberty will be taken away from them until and unless there is procedure established by law. Then immediately comes Article 22, जो कहता है, if you are arrested, then it is very, very important you to know about your grounds of arrest, and it is not about your knowledge. You have to be informed by the law enforcement agency who is arresting you. So as I just discussed, that I understood as these provision as Article 22(1) being more onerous, causing more burden, making more responsibility on the law enforcement agency of informing the person. But what happened in our journey of interpretation of this provision is Article 22 clause 5 got some momentum. It was interpreted repeatedly by the constitutional benches, whereas Article 22(1) had to wait for a very long time, as we will be discussing right now, to get its due, to get being recognized, and also to be applied to the people who were arrested without they being informed about grounds of arrest. So पहली बार जो judgment मुझे मिली 60s में ही शुरू हो गया था कि प्रिवेंटिव डिटेंशन लॉज में अगर किसी को अरेस्ट किया जाता है तो उसके डिटेंशन के ग्राउंड्स उसको कम्युनिकेट किए जाएंगे. There was a judgment of 5 judges in Harkisson, which came in 1962, and then there was another judgment also of Shobha Ram, which came in 1966. There were more judgments which continued to come. 1980 also there was a judgment of Lalu Bhai Jogi Bhai Patel. In all these judgments, the focus was on that a person who is detained under preventive detention laws is required to be informed of the communicated about the grounds of detention, and importantly, the detention ground has to be communicated effectively, meaningfully in the language which the detainee understands. Formality नहीं हो सकती क्योंकि ये फंडामेंटल राइट है. आपको अरेस्टेड बंदे की भाषा में जैसे वो समझता है, जिस तरह से उसको ये चार्ज क्या है, उसको अपने आप को किस चीज से डिफेंड करना है, जब तक आप उसको नहीं समझा देते उसकी ही भाषा में, तब तक आर्टिकल 22 क्लॉज 5 का कंप्लायंस नहीं होता. दिस हैज बीन एंडोर्स्ड बाय द सुप्रीम कोर्ट ऑफ इंडिया इन 5 जजेस बेंचेस वे बैक इन 1960s. एक जजमेंट मुझे मिलती है जो मैंने अभी आपसे डिस्कस की 66 की, मध्य प्रदेश वर्सेस शोभाराम, जहां पे एक क्वेश्चन था कि क्या राइट ऑफ लीगल काउंसिल कॉम्प्रोमाइज हो सकता है बाय मेकिंग एन इनेक्टमेंट वेयर इट कैन बी सेड दैट अ पर्सन विल नॉट बी प्रोवाइडेड विद लीगल काउंसिल्स, बट the interpretation of this provision in this judgment was that if a person is not arrested, then Article 22(1) does not come into picture. But if the person is arrested, then it is very, very important that he gets a representation of the council. This is another part of Article 22. I have not read it before you when starting the discussion, because today our focus is only to understand importance of information of ground of arrest when a person is arrested. The reason I'm sharing this judgment with you, though it was about the right to be defended by a counsel, there is a very important observation in this judgment by 5 judges, which says that a person who is arrested has to be informed about the ground on which he is arrested. This requirement cannot be dispensed with by taking bail from him. The need to tell him why he is arrested remains still. This judgment first time interpreted how important are the information about grounds of arrest to a person who is arrested. So far, all the discussions, all the research, if we do, we will find there are a lot of judgments on interpretation of Article 22(2) to be produced before magistrate within 24 hours, Article 22(5), which I said. But there is a one hope, one small silver lining, which happened in 1968. Now the judgment is again being recognized, mentioned in the latest judgment, is Madhu Limai's judgment by 3 judges at that time. In this case, Madhu Limai, a politician, was arrested apparently for a bailable offenses when he was going for a protest along with his supporters. But उसने bail नहीं भरा. He asked the police officers कि आप मुझे arrest किस बात के लिए कर रहे हैं, लेकिन उसको grounds नहीं बताए गए. Article 32 में writ file की गई Supreme Court में, and the Supreme Court said that no, the information had to be provided immediately. Bail से information देने का जो Article 22(1) का mandate है वो solve नहीं होता, and it is the duty of the state to establish that when the magistrate was directing the person in custody while giving remand, all the magistrate has applied its mind to all the relevant matters. The magistrate saw that Article 22(1) and other provisions were complied with or not. And if the magistrate has not done so, state has not pointed out how the provisions are complied with, and very mechanical remand orders have been passed, there is a violation of Article 22. Even if the offense was bailable and the person himself did not furnish the bail bonds, the arrest was bad or illegal, it has to be quashed. 1968 की ये जर्नी, जब मधु लिमाय की जजमेंट में पहली बार पता चला कि आर्टिकल 22(1) is so important and it has to be very meticulously complied with the law enforcement agency. Maybe that was the reason that when we got a new Code of Criminal Procedure on the eve of 24 years of Constitution, that is 25th January 1974, our CRPC 1973 came into force, we got Section 50, Clause 1 in the Code of Criminal Procedure. And in this, it was specifically mentioned that every police officer or any other person arresting any person without warrant shall, there is a change now, forthwith. In the Article 22, the language was as soon as may be. But here in Section 50 CRPC, the language used was shall forthwith. The word information was substituted with the communication. 2 more changes come in this provision now. Full particulars of the offense or other grounds for such arrest. Whether or particular of the offense or other grounds can be either ways or can be in substitute to each other has been answered by the Supreme Court in the latest judgment of Vihan, which we will be discussing. But this was the change which came in 1974 from constitution. The provision has now traveled to a statutory provision of CRPC, which I understand by using the word forthwith, giving it more force, making it more incumbent upon any law enforcement agency to inform the person of grounds of arrest while arresting them. This provision has been retained in BNSS in section 47. इसी तरह के जो प्रोविजन सीआरपीसी में आए फिर हमारे एक्ट्स में भी आने शुरू हो गए. सेक्शन 52 एनडीपीएस एक्ट हैज द सेम प्रोविजन लाइक आर्टिकल 22 एज सून एज मे बी. फोर्थविथ किसी भी एक्ट में नहीं आया. फोर्थविथ ओनली रिमेन्ड इन सीआरपीसी. 19 PMLA 2002, UAPA 43B 2008, कॉफेपोजा एक्ट अगेन NSA डिटेंशन लॉज. सो ये प्रोविजन कॉन्स्टिट्यूशन से डिफरेंट स्टैट्यूट्स में आते रहे. मोर और लेस लैंग्वेज सबकी वही रही जो आर्टिकल 22 की थी. अब मधु लिमाय के 1968 के बाद पहली बार जब लगा कि ये फंडामेंटल राइट हो सकता है, फंडामेंटल राइट इसकी एप्लीकेशन बहुत जरूरी है व्हेन अ पर्सन इज बीइंग अरेस्टेड, दो इट वाज डिस्कस्ड इन डिटेल in October 2023 in Pankaj Bansal's judgment, but the foundation of that discussion was laid down in August 2023 in a case of V. Senthil Balaji. It was by two judges of the Honorable Supreme Court. The discussion was about Section 19 PMLA. Section 19 PMLA says about the requirement of grounds of arrest to be informed, but it has certain other requirements also, which says that any authorized officer who is wanting to arrest a person has to form reason to believe, based on the material available, that whether a person is guilty of the offense or not, and then also may arrest. It is not compulsory. In our last lecture also, I have discussed with all of you that there is no law in India which makes the arrest compulsory. Even in 302, which is now 103 BNS, there is no compulsion to arrest because provision says officer may arrest. So in section 19 PMLA also, the section says that on making the reason to believe that a person is guilty of an offense, the authorized officer may arrest. But once he arrests, then the language of the section is shall inform the grounds of arrest as soon as may be. So arrest is optional, but once you arrest, then the information providing to the arrestee is mandatory under law, and there absolutely is no scope for any officer not to do it. इसी जजमेंट में एक लाइन आ गई, उनको रिलीफ जो इसके पिटिशनर थे वी सेंथिल बालाजी, उनको इस केस में कोई रिलीफ नहीं मिला था बिकॉज on the fact it was found out that he was informed about the grounds of arrest, he did not take it, he tore it away. So there was a compliance in a way, but somehow he himself was not taking the grounds of interest from the law enforcement agency. But ratio में इस judgment की Supreme Court ने lay down किया that if there is any non-compliance of section 19 of the PMLA, it would inure to the benefit of the person arrested. There was another very interesting observation of the Supreme Court, which so far I have not seen being acted upon in any of the judgment passed by Supreme Court or any of the High Court, as far as my knowledge goes, subject to correction by anyone else who has done more research on the subject. The Supreme Court also observed that for such non-compliance, the competent court shall have the power to initiate action under section 62 of the PMLA. Section 62 says that if any officer is arrested a person without giving reasons in writing, that person can be punished, officer can be punished for 2 years or for fine. But that has, though there are so many judgments when it has been found that arrest was not proper, it was illegal arrest, grounds were not given properly, there was no need to arrest. But I have not seen any judgment where the recommendation of taking any action against the arresting officer under this provision has been made. इसी जजमेंट में एक और इम्पॉर्टेंट ऑब्जर्वेशन थी जो सारे लॉयर्स के लिए जरूरी है कि what happens if a person is arrested in violation of the statutory provision that because we know that when a detention is illegal, it is against the provision of law, there is a writ of habeas corpus line. So in this judgment, Supreme Court also answered that though for illegal detention against the provision of law, writ of habeas does lie, but not in all cases. Writ of habeas lies only when there is a violation of statutory provision. But if there is a judicial order, then writ of habeas will not lie. The person affected by the illegal arrest as well as by the judicial order has to take the remedy available to them under the various provisions of law. But at the same time, the judgment also said that if the order is very cryptic, it does not give any reasons at all. It does not take into consideration, is totally oblivious of Article 22(1) and Section 19 and any other statutory provision. उस हालात में भी a habeas corpus writ can be filed. And most importantly, that is why I hope that everybody who is going to the trial court and appearing as a lawyer resisting remand application by the police, especially to the legal aid council, if anybody has joined a session today, because I understand that there are specifically remand lawyers given to the accused, that it is the duty of the lawyer to tell the magistrate now that whether there was a compliance of Article 22 Clause 1 as well as Section 19 or any other provision of the Special Act while the person was arrested. So in this case, for the first time, the court only held the Section 19's requirement is absolutely essential. अगर इसको फॉलो नहीं किया जाता तो इसका बेनिफिट अरेस्टेड एक्यूज्ड को मिलेगा, एनफोर्समेंट एजेंसीज को नहीं. बट प्रैक्टिकली फैक्चुअली इस केस में एक्यूज्ड को कोई बेनिफिट नहीं मिला. उसके बाद आती है हमारी एक बड़ी इंपॉर्टेंट जजमेंट विच इज कॉल्ड पंकज बंसल. दिस केम ऑन 3rd October 2023 and this date also would be very, very relevant because of some phrases used in this judgment and interpretation of that phrase henceforth in subsequent judgment of Ram Kishore Arora. I do understand there are some messages in the chat box about the citations. In the end, I have made a page for all of you. I'll screen share that and I will request Vikas to keep the screen frozen for 1 or 30 to 40 seconds for all of you to take a screenshot. So citations you will all will be getting. In Pankaj Bansal's case in 2023, personally I found that after 55 years of Madhu Limais, which has come in 1968, first time Article 22 Clause 1 was being discussed. That if the arrest does not have information as it has been mentioned in this provision, then the arrest is vitiated. So taking this step further, the court, in Pankaj Bansal's case, the court referred to Senthil's judgment and the Supreme Court says after Senthil's judgment, it is very clear if Section 19 of PMLA is not followed, the benefit has to be given to the accused. But now the Supreme Court took one step ahead. The Supreme Court said the information the sharing of information, the giving of information to the accused is absolute, compulsory, mandatory. But the question now arises is how this information has to be given. And the court also observed that this aspect, how, in what manner information has to be given, has not been discussed either in Vijay Madalal Chaudhary's case. Those who do the PMLA matters know about this judgment. And also in V. Senthil Balaji. The only thing which the Supreme Court noted in V. Senthil Balaji was that information of the grounds of arrest should be served on the arrestee, but did not elaborate. So now, taking cue from the word serve, the Supreme Court held in this case that serving doesn't mean oral communication. Serving doesn't mean what the officer says, words of officers against the words of the arrestee. Serving means something substantial, something meaningful, something tangible, which the court tomorrow can judicially review whether this information was given or not given. So while discussing all these issues, Pankaj Bansal's case is also very relevant for all the lawyers who are practicing on the criminal law side to see whether the police is just not only ED, but the police also is justified in arresting a person or not. Because in this judgment, the Honorable Supreme Court observed that if a person is not answering questions, the person is not cooperating in the language of enforcement agency, which means not confessing, evading question is not a ground of arrest under section 19, and that will be applicable for other arrest under other provisions of law as well. The Honorable Supreme Court in this judgment also observed that when in Vijay Madanlal Chaudhary's case, the vires of section 19 was upheld, and the court also was saying that it's all right if enforcement directorate does not give ECIR, doesn't matter as long as they are informing the arrestee person about grounds of arrest as mentioned under Article 22, Clause 1. So, taking cue from that judgment, Supreme Court in this case, for the first time, as far as PMLA was concerned, said that Article 22(1) is a fundamental right. So the mode of providing information has to be meaningful so that purpose is served. It also said that ground of arrest helps to prepare defense. A person who's arrested is not calm. He is stressed. Just showing him bulky of papers and saying that yes, the grounds of arrest have been complied because we informed them orally is no compliance at all. And moreover, ground of arrest are very personal to the person, but sensitive information it can be which any law enforcement agency is not ready to share. So the court ultimately held that it is a fundamental right, and henceforth, from this judgment, the copy of grounds of arrest has to be furnished to the arrested person as a matter of course and without exception. What happened is, because the court uses the word henceforth, judgment which we'll be coming to and discussing in a while has held that henceforth means that requirement to give grounds of arrest in writing is a requirement which will come to the and will be applicable to the arrest which are made after 3rd October 2023, not before that. But as I understand the law, the irony is that a Pankaj Bansal, who got the benefit of this judgment, whose arrest was held to be illegal, quashed, his liberty restored to him, was arrested before 3rd October 2023, not after that. So now Pankaj Bansal judgment recently laid foundation for Section 19. Pankaj Bansal said how Section 19 has to be informed. Then came a judgment in December 2023, Ram Kishore Arora, where two things happen. One, the court said oral communication is sufficient. Two, written communication requirement would be applicable, would be required after the judgment of Pankaj Bansal, because the word uses henceforth. This judgment also would be relevant for the lawyers and law students for the point of view, because this is the judgment which has also discussed the meaning and duration of as soon as may be. So as per this judgment, as soon as may be means 24 hours, because that is the time before within which the arrestee person has to be taken before the adjudicating officer, has to be informed, person has to be taken before the magistrate. So as soon as may be, as mentioned in Section 19, means 24 hours. And though whenever Article 22 Clause 5 was interpreted for as soon as may be, the Supreme Court has been very, very categorically that it has to be as soon as possible for the person to show that this is the time within which they could have provided the information. 24 hours in this case, to my understanding, is little too much of a time for an authority to keep a person under detention without telling that person that what are the grounds of the arrest, why that person has been arrested, why his liberty has been taken away from him. Moreover, as far as section 50 CRPC concerned, where the word forthwith is used, will not be fitting in this interpretation of phrase as soon as may be done in this judgment. PMLA के इन 3 जजमेंट के बाद जो बहुत सारे लॉयर्स भी मानते हैं, उस पर बहुत डिस्कशंस भी है कि सबसे ज्यादा वाटरशेड मोमेंट, सबसे ज्यादा इंपॉर्टेंस, इम्पेटस, सबसे ज्यादा ग्राउंड्स ऑफ इंफॉर्मेशन की सैंक्टिटी को जो फोर्स मिलता है, दैट इज द जजमेंट ऑफ प्रबीर पुरकायस्थ, which we will be discussing, which is about requirement to provide grounds of arrest when a person is arrested under UAPA, which has the similar provision, same stringent law as PMLA, twin condition before person gets bail, and same law requirement that a person has to be given grounds of arrest as required under PMLA. This judgment of Prabir Purkayas came in 2024. So 2023 belonged to the PMLA. 24 judgment, this UAPA judgment came in on 15th May 2024. In this judgment, it was discussed in detail that Pankaj Bansal pari passu applies to UAPA, though there was an effort and attempt by the state to show there is a difference between the two laws. Those judgments are only unique and applicable to PMLA. UAPA में judgments नहीं लग सकती हैं, but court held no, it is applicable. But what has been further discussed in this judgment is a lawyer's delight, and everybody who's a champion of a person's liberty, that how in this beautiful judgment, Honorable Supreme Court for all times to come has protected, preserved liberty of many people, at the same time imposing some obligation and inculcating that responsible feeling of law enforcement agency कि आपके पास पावर है लिबर्टी लेने की, वो बहुत बड़ी पावर है, उसको ध्यान से लीजिए. And not only you, even the courts are under responsibility to see that liberty which is taken away from a person is taken away only and only when proper procedure of law has been followed. So इस judgment में court ने आगे जो होल्ड किया है वो ये है कि whenever a person is arrested and proper information about reason for arrest, grounds of arrest are not given to him, not only the arrest but also remand order gets vitiated if Article 22(1) is not complied with. The most important and beautiful observation of this judgment was that the court held that not only UAPA, not just PMLA, but any other offense, because this is Article 22 Clause 1, which is applicable to each and every person who's arrested under specific law, general law, anywhere. So the requirement of providing grounds of arrest is not just for statutory law, not just for the specific where there is a specific provision corresponding to Article 22, but for each and every case. And the provided information has to be complete, meaningful, so that a person can discuss with the advocate, can oppose the police custody, and also can use that information to seek his bail. The court held it is very sacrosanct. There cannot be any exception. This has to be protected. There is absolutely no scope for the law enforcement agencies not to comply with. Another important observation which came in this judgment is only because a charge sheet has been filed, investigation is done. Now the police find that a person has done something, there is an evidence against this person is liable to face a trial. This also will not cure the first defect. If the arrest was illegal, it will not be validated because now after the investigation, prima facie offense is made out. Something is wrong, it is wrong. So fact of filing of charge sheet will not impact the arrest which has been illegal and the person was not informed about the grounds of arrest when the person was arrested. Another important aspect which was discussed in this Prabir Purkayas judgment was difference between reason for arrest and ground of arrest. And this need arose because the court said that arrest memo is not a ground of arrest. Arrest memo could have some reasons to arrest, that why a person is being arrested, which is very subjective to the investigating officer who's investigating the case, who has his own causes, his own reasons to arrest. But the grounds of arrest are very, very personal to the person who's going to be arrested, that is specific to that person. So therefore, having an arrest memo, filling the form for reason for arrest is not a substitute of ground of arrest, which is mandated and required under Article 22, Clause 1. The court also held something very important, that just picking up some facts from the FIR, narrating it and saying that, oh, this case has been registered, this happened, this happened, this happened, so we are arresting you, also is not a ground of arrest. For telling somebody that what are the grounds on which you are sought to be arrested, your liberty has to be curtailed, has to be specific to that person, so that that person can further challenge it in the court. The court also held that the ground of arrest has to be in writing. There cannot be any scope for providing information orally, because nobody can get it registered in the mind when a person is under arrest. For making it effective, it has to be in writing. So पुरकायत की जजमेंट के बाद ये क्लियर हो गया कि ग्राउंड ऑफ अरेस्ट हर ऑफेंस में चाहिए. इसको ये सिर्फ PMLA UAPA जैसे स्पेसिफिक लॉ जहां पे ट्विन कंडीशन स्ट्रिक्ट बेल है वहां के लिए ही नहीं है, जहां स्ट्रिक्ट कंडीशन नहीं भी है वहां के लिए भी है. राइटिंग में ही मीनिंगफुल इंफॉर्मेशन होती है. प्रोस्पेक्टिव आर्ग्यूमेंट लिया गया था इस केस में कि ये आप पंकज बंसल वाले केस के डील कर रहे हैं और उस केस में henceforth वर्ड यूज किया है, तो डिस्कशंस नहीं था, रेशो नहीं है, बिकॉज नाउ दी judgments of by different high courts are also granting quashing the arrest even if it was made before 3rd of October 2023 if grounds of arrest were not informed. But इस particular case में Supreme Court ने कहा factually Prabir Purkayast was arrested on 4th October. Pankaj Bansal had come, even though it was not uploaded, nobody knew, that is immaterial. But the question is, Article 22(1) exists in the constitutional provision since 1950. So once it is a part of the law, part of the constitution, part of your fundamental right, I personally believe we cannot say that when any judgment says that it is effective and it has to be applied. If it was not noted before, that doesn't mean that provision ceased to exist, and more so when that provision is a fundamental right. Same year, so this judgment is very, very important. I'm sure most of you have read it. If you have not, please go through it, because that judgment will give you a lot of more arguments to file an application to challenge the arrest if it was made in violation of statutory provision, as well as, most importantly, Article 22, Clause 1, constitutional provision. 2024 में ही एक और judgment आई थी, which was Arvind Kejriwal versus Directorate of Enforcement. In this judgment, the observation, it has nothing to do with the ground of arrest as such. It is more about the reasons of arrest, necessity of arrest. But there are some few observations which will be important for anybody who's making an application and challenging the arrest. In this judgment, the Supreme Court observed that any undue indulgence and latitude to the Directorate of Enforcement will be deleterious to the constitutional values. Section 19 of PMLA cannot be exercised as per the whims and fancies of the officer, and the decision-making process is required to be judicially reviewed. That will be applicable not only to the ED, but to the all police officers. Any police officer who arrests a person, the reason for his arrest, why he is arresting, the reason for his ground of arrest, it is not just a paper formality that a person writes it, gives it to the accused, and that is not making any sense at all. The court will say, no, the provision has been complied with, because in letter, there are grounds of arrest, in paper in front of us. No. Spirit of the provision is of paramount importance. The court has to see that whether the subjective opinion of the officer concerned who's arresting the person has actually some rationale, has met the spirit behind having this provision, that nobody is arrested without valid reason. Nobody is arrested as a measure of harassment to that person. So, and also in this judgment, the court noted very important aspect that now after Arnesh Jha, Mohammad Zubair, Siddharth's matter, Supreme Court has been repeatedly saying that power of arrest, though it uses the word may and gives a lot of discretion to the enforcement and investigating agency, it is very important for the court to see whether there was a necessity to arrest or not. The court said that necessity to arrest is not mentioned per se in section 19 of PMLA, which only says you have reasons to believe the person is guilty, you may arrest and inform the grounds. It doesn't say that whether you are required to arrest or not. In this case, the Supreme Court framed the question and said no, necessity of arrest has to be seen. And now, in view of earlier judgment by the Supreme Court in Vijay Madanlal Chaudhary, let this aspect of need and necessity of arrest in PMLA matters be examined by the larger bench. So it was in July 2024. The latest research shows till date it is again pending. There is no larger bench constituted. Mr. Kejriwal got interim bail, but the question of necessity of arrest in PMLA matter is still awaiting the final outcome after the larger bench is constituted. Now comes the main reason why we are discussing this provision of information of ground of arrest, not only in specific cases, but also in general laws. And it comes as a very pleasant observation of Supreme Court to me as a lawyer, but also as a very sad moment that it was in 75th year of Constitution that Article 22 and Article 21 got its due as far as right of arrested person were concerned. And Supreme Court passed a judgment of Vihan versus State of Haryana on 7th February 2025. This judgment is not about 19 PMLA, it is not 43B UAPA, it is not NDPS, it is not any other specific law which has strict bail condition. This is for the first time that Section 50 CRPC, which is 47 BNSS, was discussed under the umbrella of Article 22(1), and the court, in no ambiguous terms, absolutely clearly said this is non-negotiable, even in general laws, even in the arrest for IPC. In this case, it was 424/67. The requirement to provide grounds of arrest meaningfully, effectively is absolutely essential and applicable, and there cannot be any scope, any leniency to the enforcement agencies not to do it. So the court held certain key takeaways from this judgment, which would be, in my understanding, almost 11 in number, is one, Section 50 CRPC is applicable to general laws, and it says the person has to be informed about particular of the offense or such grounds. So there was an argument by the state saying or means particular of offense, like writing this section is sufficient. Supreme Court said no. Section 50 is important, but not more important than Article 22(1). Section 50 को अपनी soul और spirit Article 22 clause 1 से लेनी है. Grounds of arrest Article 22(1) के important हैं. Section 50 का और उसको dilute नहीं कर सकता. So grounds of arrest तो देने ही पड़ेंगे. Particular of offense additional हो सकते हैं, substitute नहीं हो सकते हैं. The court again held non-informing grounds of arrest is not just violation of Article 22 clause 1, it is violation of Article 21 also, because not only procedure established by law is not being followed, procedure established by constitution is not being followed. So if a person is not informed grounds of arrest, Article 22 के साथ साथ Article 21 भी violate होता है. Mode of conveying has to be meaningful. No ritual exercise. Simple paper formality नहीं चलेगा. Arrest memo, ground of arrest नहीं है. Very, very clear. Case diaries, ground of arrest नहीं है. जब तक कोई contemporaneous document ये नहीं दिखाता कि ground of arrest communicate हुए थे effectively. पुलिस ऑफिसर का अपनी केस डायरी में लिख के कोर्ट को दिखाना कि हमने कर दिया कंप्लायंस इज नॉट सफिशिएंट ग्राउंड. हाई कोर्ट ने इस केस में केस डायरीज को देख के कहा था ग्राउंड ऑफ अरेस्ट कम्युनिकेट हो गए. सुप्रीम कोर्ट सेड हाई कोर्ट इज एब्सोल्युटली रॉन्ग. इट्स अ फंडामेंटल राइट. इट कैन नॉट बी diluted, it cannot be undermined by resorting to such tactics. The court also held कि mentioning of ground of arrest in the remand application is no compliance. You cannot say that when we move the remand application before the authority to take police custody of the arrested person. We wrote in detail why we need his remand and what are the grounds of arrest. Court said no. That is about your getting an order of police custody from the magistrate. Here it is required what information you have given to the arrested person. That writing of that words in remand application is no compliance. The court again held, which has already been held in Prakaya's case, that filing of charge sheet, cognizance of offense will not validate any unlawful arrest. आपकी prima facie case find करने से पहली arrest जो constitutional provision के खिलाफ थी, उसकी compliance नहीं होती है. The court also held that burden to prove compliance of Article 22 is on the investigating officer. Once the arrested person says that I was not given ground of arrest, I was not informed, the burden to prove that he was informed is on the investigating officer. Then it is a duty of the court, which is giving remand of the accused, either judicial or police, to ensure that compliance of Article 22 has been made. If it is not done in the remand order also gets vitiated for violation of Article 22 as the arrest itself gets. The court also clarified one thing, though we saw in certain cases of NDPS that when Section 50 of NDPS, 42 statutory provisions were not complied with, entire trial was vitiated. Here the court clarified that when the Article 22 is not complied with, when the arrest grounds are not informed or communicated, arrest is vitiated, but there is no effect on the investigation and trial. Only the arrest is vitiated, and the person's liberty has to be restored. The case will not be quashed, case will continue. And the court also clarified that this is applicable even for the twin condition stringent laws. Once the offense, the provision is, once the person is not informed about grounds of arrest, the arrest is vitiated. Even if there are strict conditions that a person will not be released on bail till he proves that he's not guilty, like Section 37 NDPS or Section 45 PMLA, still, if arrest is vitiated, person would be released. His liberty has to be restored to him. I would request all of you to please read para 26 of the Vihan's judgment, where all these directions are given. And in the second judge supplementing the observation of the first judge also said that right to inform about grounds of arrest is not only to the arrestee, but his friends, relatives, and other person as are required to be informed just about the fact of arrest. They have to be informed about the grounds of arrest as well. After the February 2025, there came a judgment of Supreme Court in Mihir Rajesh Shah on 22nd April that is reserved, still reserved. The judgment has not come out. In this case, Supreme Court said that the question is whether in each and every case under IPC, a person who's not furnished grounds of arrest, his arrest would be vitiated and has to be released, or if there is scope of some exception in some cases due to some extraordinary circumstances that grounds cannot be provided. But because of these very reasons, the arrest will not be vitiated. The judgment is reserved. It has not come out. So all of you are requested to keep a watch and see when it happens and what finally Supreme Court says. This judgment again has been noted in judgment of Supreme Court in Karnataka versus Hemant Datta's case, which was taken before the Supreme Court recently on 26th June 2025, which is again still pending. State of Karnataka has, relying upon Vihan's judgment, started releasing. The Karnataka High Court has passed many judgments where a person who's even arrested before the date of Pankaj Bansal's judgment, but grounds of arrest were not communicated to them in writing effectively, meaningfully. All these arrests have been declared to be illegal, and all these persons are being released. There was a specific request by the state of Karnataka before Supreme Court to stay the judgment so that it doesn't become a precedent and now not wait for the judgment of Supreme Court in Mihir Shah case because it is not coming. The court kept the matter, but still it is not being heard. So that judgment is also something to watch for. Finally, Supreme Court IPC cases may in requirement of ground of arrest ke baare mein kya kehta hai. There is another judgment in between, which is Kasi Reddy, Upender Reddy. In this judgment, though on the apparent having at the very first, when we read the judgment, it shows that once there is a arrest pursuant to the warrant, then the requirement of grounds of arrest will not be as important as it is for the arrest without warrant. But if we read the judgment in entirety, we will see that in this judgment, Vihan's judgment has been endorsed. The court even mentioned it to be a path-breaking judgment. That means it is very much applicable. The court said in this case, the petitioner wanted, though they were given written grounds of arrest, but they were saying it is not meaningful, it is not having all the particulars, it is not containing all details for which they were arrested by the arresting officer. So the Supreme Court said no. They have seen the material was sufficient, and it is not that for every ground of arrest such kind of detailed information is required. And in that process, an observation was made that if an arrest is pursuant to the warrant, that itself would be sufficient compliance of Article 22, Clause 1, and the arrest will not be vitiated on that count. But we have to see in future cases that whether when the warrant is cryptic, warrant is not having sufficient information, only because a judicial officer has passed that order without understanding the mandate of Article 22, Clause 1, will it be sufficient for deprivation of liberty of another person, because that arrest is coming from the order passed by the judicial officer and not the investigating officer. In this case, that was not the case. The case was something else. So it is just in passing observation. In future times, we have to see how this law evolved. From Prabir Purkayas to Vihan's judgment, the Supreme Court has really taken a very, very strong stand in favor of the liberty, and has given one very strong reason for a person to get bailed out when the proper arrest grounds are not being communicated and not informed to that person. It's almost 2 minutes before 7, so I could complete what all I had to share with you in my allotted hour of time of 1 hour, 2 minutes less. It will be open for the questions now as Vikas wants. But before that, I would like to share that one chart, Vikas, which I have made for everyone. Just let it be there for 30 to 40 seconds so that everyone can just take a screenshot. And I would also request you to, if you can just pin it with your YouTube channel later on. I'm not able to share my screen. Can I share my screen? Will you permit me to do that?
Just try that.
Host is not allowing sharing. Okay, ho gaya. Yeah. Can people see my screen now? Can you see my screen? No.
I will share it on the WhatsApp.
All right.
On the WhatsApp.
All right, I'll do that. I'll share it with you. You share it all. It has all the citation, date wise, what happened, and then it can also be pinned into your YouTube. Yeah. Let me see. There were some questions in the chat. If we can answer it. How should 24 hours be calculated in case holidays and weekends? As far as my understanding of criminal law comes, there is no question of any holidays and weekends. The moment a person is arrested, within 24 hours, he has to be produced before the duty magistrate, even at that person's house. So there is no scope of any leverage for holidays or weekends. जैसे ही अरेस्ट हुए हैं तभी से 24 घंटे की क्लिक टिक 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 शुरू हो जाती है. The real problem comes is पता कैसे चले किस टाइम पे अरेस्ट हुए हैं, because police many times show the time to be later. There are phone numbers. This happened. Contact this police. If yes, then how police? Please, case law you will be getting. Is it mandatory to provide copies of remand at the time of the presence of the accused before the magistrate within 24 hours for police custody or magistrate custody? Absolutely. It is very, if you read the judgment which is passed by the Supreme Court, once a person is produced before the magistrate and a police wants a police remand, the reason for that remand has to be given to the accused. The court said it is your right to know it. Rather, in one of the judgment, the application was endeavored to be taken as a substitute of information of ground of arrest. ये हमने रिमांड एप्लीकेशन में लिख दिया, रिमांड एप्लीकेशन हमने शेयर कर दी थी एक्यूज्ड के साथ. सो नाउ इट इज सफिशिएंट कंप्लायंस ऑफ आर्टिकल 22 क्लॉज 1. तो कोर्ट से नहीं, वो तो अलग से देना ही है. सो रिमांड एप्लीकेशन के कंटेंट एक्यूज्ड को पता होने चाहिए, उसके लॉयर्स के पास होने चाहिए. उसके बिना तो रिमांड एप्लीकेशन कंटेस्ट ही नहीं हो सकते. दिस इज योर राइट टू आस्क फॉर इट. There is a very interesting question that when ordinary citizens are arrested, detained for peaceful protest, what are steps to be taken as a lawyer? In that case, as if we just focus on today's topic, the very first step is to ask for why are you being arrested? Because if you read Madhu Limai's judgment of 1968, something like this only happened. Section 144 was imposed. More than 5 people could not gather. They were not allowed. And then they were arrested and they were told that is a bailable offense. We were just arresting you, just furnish your bail bonds and go. But Mr. Limai said, no, आप कारण बताइए, आप अरेस्ट क्यों कर रहे हैं? कारण था नहीं, बता नहीं पाए, सेक्शन कौन से लगते क्लियर नहीं किए, क्यों पकड़ा गया नहीं बताया. और सुप्रीम कोर्ट ने आर्टिकल 32 में कहा 22(1) का वायलेशन है, अरेस्ट विशिएटेड है, हम सबको रिलीज कर रहे हैं. तो जब कोई पीसफुल प्रोटेस्ट में पकड़ा जाता है तो पहले पूछिए ऑफेंस क्या हुआ है, ग्राउंड ऑफ अरेस्ट क्या है. प्रोहिबिटरी ऑर्डर में आपको किसी को डिस्पर्स करने का तो है, अरेस्ट करके अंदर कैसे लेके जा रहे हैं आप. And yes, Srinath started with this, that audio alterum partner was absolutely right, which is something I always feel that criminal law में कैसे without hearing somebody is immediately put behind bars and when this will change. If arrest is declared to be vitiated, illegal by the magistrate at the time of first production, whether the arrested person would be released without him furnishing bond or would he be granted bail. There are some judgment which says once the arrest is vitiated, it is a wrong arrest. It is, you were not required to be arrested at all. There cannot be any question of taking a bail. Your arrest is quashed. It is null and void ab initio. But in some judgments, especially in Prabir Purkayas, the court specifically dealt with it. The court said, ideally, when the arrest is vitiated, we have to call it wrong arrest, false arrest, should not be there, release the person immediately. बट वहां पे क्योंकि कोर्ट में चार्जशीट फाइल हो गया था, तो कोर्ट ने बोला कि बेल बॉन्ड्स फर्निश करो. इसके आगे एक और चीज, सेकेंड corollary of this is, now there is a question which is kept open by the Supreme Court in Prabir, yeah, maybe in Vihan's case. There was an argument that if the arrest is quashed and the person is not asked to furnish bail bonds, can the investigating agency re-arrest them? This question arose before the High Court also, but that was the first arrest, hypothetically dropped. Supreme Court in Vihan's judgment said, अभी हम इसमें डील नहीं कर रहे, जब करेंगे तब देखेंगे. So एक क्वेश्चन ये भी होता है कि अगर आपने बेल नहीं दिया, सिर्फ अरेस्ट क्वाश हुआ है, तो इन्वेस्टिगेटिंग एजेंसी आपको दोबारा से भी अरेस्ट कर सकती है. Is any citation related to providing remand copies of the accused? ये अभी इस टाइम पे तो याद नहीं है मुझे, बट आप इसको अगर आप विहांस की और प्रबीर पुरकायस की जजमेंट पढ़ेंगे, वहीं से आपको क्लियर हो जाएगा कि रिमांड कॉपीज हैव टू बी गिवन टू द एक्यूज्ड. चैट बॉक्स, ये तो हो गया. आई थिंक आई हैव आंसर्ड ऑल द क्वेश्चंस. जो अगर मैं कोई मिस कर गई हूँ तो विकास, यू कैन आस्क मी. आई एम जस्ट क्लोजिंग इट नाउ.
YouTube. Can the defense call for the DDR of all the persons arrested on a particular day to prove that the accused was arrested a day prior to shown? RTA application for record denied, appeal still pending.
No, because this case diaries, accused doesn't have any right. Only court, if it wants, it can see. Accused doesn't have any right to see the case diaries of the police. Only court can see if the court wants. So that, and as far as RTI is concerned, I have not read that act in such depth, but I remember, I think investigation is out of the purview of RTI. You cannot, nobody can seek any information in ongoing investigation under RTI. It doesn't come under the purview of the act.
So thank you, Tanu, for sharing your knowledge. And as and when Tanu shares the citation of the judgments, not only of this session, but of the previous session, we will upload in the website. I'm just sharing the link. You can connect us on the WhatsApp. We will share the link of the website also.
I really made this spending 10 minutes today because वो मेरे को बहुत छोटा करना पड़ा कि मैं screen share करूँगी, but you are not permitting me to share screen.
I've shared the website. So thank you, friends.
I'll give it to you.
Thank you.